नमस्कार दोस्तों, वकील साहब इंडिया में आपका स्वागत है। आज फिर एक नए लीगल क्वेश्चन के साथ। क्वेश्चन बहुत इंपॉर्टेंट है जुडिशरी के पॉइंट ऑफ व्यू से, लॉ एग्जामिनेशन के पॉइंट ऑफ व्यू से, और अक्सर जनरल इस पर के क्वेश्चन कोर्टों के अंदर रेज होते हैं कि इशूड ए लीगल नोटिस टू बी डिमांडिंग सर्टेन अमाउंट। भाई, आपने अपने भाई की शादी पे हमसे कुछ पैसे लिए थे, हमें वो पैसे प्लीज मेहरबानी करके वापस कीजिएगा। बी उस नोटिस के जवाब में कहते हैं भैया हमने आपसे कोई पैसे नहीं लिए, ना हमारा कोई लेन देन है, और ये आप लोगों ने लीगल नोटिस भेजा है बिल्कुल गैर कानूनी है, फॉल्स है, झूठा है, हमारा कोई आपसे कोई लेन देन है ही नहीं है। आपने लीगल नोटिस इसलिए मेरे पे भेजा है क्योंकि आपने एक बार किसी लड़की की, किसी वुमन की और इज्जत के ऊपर हाथ डाला था, और उसके पति ने आप मेरे कहने से, मेरे उकसाने से आपके खिलाफ कुछ कंप्लेंट दाखिल की थी। इसी रंजिश की वजह से, इसी दुश्मनी की वजह से, इसी इलविल की वजह से आप लोगों ने ये लीगल नोटिस जारी किया है। इस लीगल नोटिस का जवाब बी ने एक रजिस्टर्ड पोस्ट के जरिए के पास भेजता है। जब वो नोटिस के पास पहुंचता है तो उसके बाद के बी के खिलाफ एक कार्रवाई करता है डिफेमेशन केस की, और वो थाने में जाकर एक FIR रजिस्टर करा लेता है अंडर सेक्शन 500 IPC के तहत। ड्यूरिंग इन्वेस्टिगेशन बी इस बात को दोबारा से रिपीट करता है, मानता है हाँ जी मैंने ये सब चीज़ें कहा है के को, और साथ में ये भी कहता है ये सब चीज़ें जो लीगल नोटिस भेजा गया है ये सब सिर्फ दुश्मनी की वजह से किया गया है, इलविल की वजह से किया गया है, रंजिश की वजह से किया गया है। आइए इस केस को कैसे डिसाइड करते हैं। टू सॉल्व दिस क्वेश्चन in hand, we will have to see legal provisions and intention of the parties and the relevant legal pronouncement, judgment declared by the court. The aforesaid case can be divided into two parts. One, FIR has been lodged. Second, B admitted the imputation made against by the B, and B also admitted the ill will and previous enmity between B and K. First question, whether FIR can be registered under section 500 IPC? What is the law in this regard? Admittedly, in first rule of the Code of Criminal Procedure, offence under section 500 IPC has been shown as a non-cognizable offence. Admittedly, as per section 155 of the CRPC, in non-cognizable offence, no investigation can be done without the prior permission of the competent court. Hence, as such, there is a bar for registration of FIR under section 500 of IPC. Section 155 mandate as under. Admittedly, charge sheet has been filed under section 173 CRPC against the accused under section 500 IPC, which is a non-cognizable offence. It is set law. Once the offence are non-cognizable offence, the police officer is not empowered to investigate a non-cognizable case without the order of the magistrate having power to try to such case or commit the case for trial. It is the duty and responsibility of the police officer to see that non-cognizable cases are not investigated without express order of the magistrate having jurisdiction and power to try such non-cognizable offences. The aforesaid provision of containing prior permission for investigation in non-cognizable offence is a mandatory requirement of law, and if there is non-compliance of the said provision, the investigation which is carried out by the police officer would be rendered illegal, void and without authority of law. In view of the specific statutory bar contained in section 155(2) of the CRPC, FIR could not have been registered against the accused for non-cognizable offence and could not have been proceeded to investigate the matter, and accused deserved to be discharged without entering into the merits of the case. The Supreme Court held in a landmark judgment, in case there is non-compliance of the said provision, the investigation which is carried out by the police officer would be rendered illegal, void and without authority of law. The Supreme Court further held in another case titled as Subramaniam Swamy case. The Supreme Court in Subramaniam Swamy case said no FIR can be registered is a non-cognizable offence. Hence, in view of the aforesaid legal position, investigation in the present case is without the permission of the magistrate and in violation of the first rule of the CRPC and is clearly illegal and without authority of law. Now we are coming on offence under section 500 IPC. The relevant provision of section 499 IPC are as under. Whoever by words either spoken or intended to be read or by sign or by visible representation makes or publishes any imputation concerning any person intending to harm or knowing or having reason to believe that such imputation will harm the reputation of such person is said except in the cases in hereinafter accepted to defame that person. Remember, to attract the offence under section 500 IPC, there are three main ingredients of the offence of the defamations. 1. Making or publishing any imputation concerning any person. 2. Such imputation must have been made by words either spoken or intended to be read or sign or visible representations. Such imputations must be made with the intention of harming or with the knowledge or with reason to believe that it will harm the reputation of that person. Hence, publication is therefore an essential element of the defamations. The offence of the defamation can be made only in the disseminations of the harmful information concerning another. This is expressed in the section by the words makes or published. It becomes clear that if a person merely composes a libel but refrains from making it public, he could not have been held liable for this offence. In the present case, the communication containing the imputation is sent by the accused to the complainant by post in a registered over addressed to the complainant himself. The complainant has not stated that imputation has been made public. As there is no publication, hence the offence of the defamation is not committed. Unless there is a publication to third party, there can be no offence. Consequently, the complaint filed by K against B is liable to be dismissed. Thank you very much.
नमस्कार, मैं एडवोकेट बीके आनंद आपके लिए और भी ऐसे अच्छे कंटेंट और न्यूज़ लाता रहूँगा। हमसे बने रहने के लिए लाइक करें, शेयर करें, सब्सक्राइब करें और हाँ, फॉलो करना ना भूलें।